Hello, and thank you for joining us today for this very special Mackrell International roundtable discussion about the patchwork of US data privacy laws. I am delighted to have four titans of data privacy in Sherwin, Yoder from Carmody, Torrance, Sandak, Hennessy in Connecticut, Stephanie Sparks, Hoge, Fenton in Silicon Valley, Tracy, Marshall, Keller and Heckman in Washington, DC, and Carrie O'Brien from Gust, Rosenfeld in Arizona. They are going to take you through today's session, and very shortly I'm going to be handing over to Tracy, who is chair of the Data Privacy Practice Group at Mackrell International and who's going to lead the session. Just to say that all of the slides that are on show today, links to mini bios and to the full firm bios of all of our four speakers are on there. They're all going to be circulated to everybody who's on and to everybody who's registered, along with a recording of this session.
Thanks, Keith, and thanks everyone for joining us today. Our discussion of the patchwork of US law centers around the lack of a comprehensive federal data protection law in the United States and the host of federal and state laws that apply to specific industries, specific types of data and practices that are deemed to violate consumers' rights. So we are going to start just with a brief overview of the privacy and data security landscape. And then with that background, we are going to discuss some hypothetical scenarios and how applicable laws apply to those situations. And we will end this session with our thoughts, concluding remarks about some best practices and takeaways. And certainly we encourage all of you to participate and ask questions as well along the way. So turning to the next slide, the US landscape is comprised of a host of federal and state laws, but it also, as well as industry standards. And this slide does not identify every federal law that applies, but the list does demonstrate how extensive the landscape is. And it includes laws governing a healthcare provider's collection and disclosure of sensitive health information, a financial institution's collection and use of non-public personal information, the collection of information and consumer credit reports, the online collection and use of information about children, and the collection and use of information about students. And there are also a host of media-specific and technology-specific laws that we should mention, including those governing unauthorized access to computers, the interception of communications and access to communications and electronic storage, the transmission of commercial email messages and SMS text messages, and also telemarketing calls. Many of these laws are enforced by the Federal Trade Commission or other agencies, and significantly, some include a private right of action. And in contrast to statutes that focus on specific industries or specific types of data, the Federal Trade Commission Act applies more generally, and the FTC enforces privacy and security violations through its broad authority under Section 5 of the FTC Act, which prohibits unfair or deceptive acts or practices. So for example, the FTC deems it deceptive for businesses to handle personal information in contravention of their privacy policies or other statements they make and commitments they make regarding privacy and security. And it is also unfair to not adequately protect personal information from unauthorized access or acquisition. So turning to the next slide, the state privacy and security landscape is just as complex as the federal, and many states have forged ahead and adopted new comprehensive laws in the absence of an overarching federal law. Similar to the FTC's enforcement authority under Section 5 of the FTC Act, state attorneys generals do enforce unfair, deceptive acts and practices pursuant to their own consumer protection laws. And many of those laws do allow for a private right of action as well. In recent years, we've seen that state attorneys generals often collaborate when investigating and enforcing privacy and security violations. And several states include a general requirement for businesses to implement and maintain reasonable security measures to protect personal information. And each state defines personal information in that context a bit differently. But in general, the definitions under the state data security laws are much narrower than the broad definitions of personal information. And for example, the EU General Data Protection Regulation or the new California laws and the other state laws that we will also discuss today. And some of those state laws also require businesses to impose general security obligations on their own service providers. Currently, all 50 states and the District of Columbia and several territories now have a data breach notification law. Really, the most significant issue with compliance is that each law is different. The definition of personal information is different under each law, and the obligations to notify affected individuals and residents of a particular state differ depending on some states have a threshold requirement, a threshold number of consumers that must have been affected by an incident before notification is required. And there are different triggers in terms of what constitutes a breach. There are many states also now require notification to the state attorney general or to another agency in the event of a breach that must be reported to affected individuals. So really having for businesses that operate globally, that operate nationally, and have to comply with all of the data breach notification laws, it can become unwieldy. And one consideration for businesses that experience a breach is whether, if notification is not required under certain state laws, whether they will continue to proceed with notifying all affected individuals anyway, if they have to notify individuals in certain states. So this is really the lack of a federal data breach notification law really does make data breach response complex. And I would just note in particular, this Massachusetts requires that businesses implement comprehensive written information security programs, and the Commonwealth recently amended its law to require that businesses provide that information to the Attorney General in the event of a reportable breach. With the proliferation of mobile devices, connected products and services, and the proliferation of technology, states have also started to implement laws to protect biometric information. And right now, Illinois' law is the most stringent, which it prohibits using or disclosing information such as retinal scans, fingerprints, and voice or facial scans without consent. And other states are currently considering legislation. And businesses must also consider state laws governing the recording of conversations and video surveillance, including when considering those measures for monitoring employees. And some state laws require notice of those practices and in some cases consent from one or both parties to record conversations. And we also thought it was important to mention now that at least 2 states, California and Oregon, have adopted laws governing the Internet of Things and connected devices, which would require connected device manufacturers to employ reasonable security measures.
Thank you so much. And also, I encourage you, when we're giving the talks, maybe come out from the booths. Like once the keynote starts, go sit at tables, because this is where your networking happens too.
And finally, we wanted to mention the crux of this discussion today, which is now the proliferation of comprehensive state privacy laws. So since California has taken the lead in adopting a law that in general requires businesses to post privacy policies. California recently adopted the California Consumer Privacy Act, which has many elements in common with the EU General Data Protection Regulation, but there also are some significant differences. And personal information is broadly defined under the CCPA, and the law provides new rights for consumers, new obligations on businesses. So businesses that are subject to the CCPA have had to update their privacy notices and implement procedures to respond to requests from consumers to access their personal information or to delete personal information that has been collected. And the CCPA also includes a unique requirement that California residents be able to opt out of the sale of their personal information. And the term sale is broadly defined currently, although the new California Privacy Rights Act, which takes effect in a little over a year, does clarify that a sale can extend to the use of technologies online for behavioral advertising purposes. So many businesses have also had to post a do not sell notice on their websites to comply with that requirement in the CCPA. And Virginia, and I should also mention significantly that the CCPA does include a limited private right of action in the event of a data breach that requires notification to individuals. But as I mentioned before, the term personal information under data breach notification laws is defined a bit more narrowly than under the CCPA and under the EU GDPR. So in some respects, it is not the private right of action is not a broad right. There has to be an incident that impacts more sensitive information, such as social security numbers, financial account information, government identification. California also includes medical information and health insurance information in the definition of personal information for breach notification purposes. And we've also seen more states have amended their laws to include a username and a password that would permit access to an online account in the definition of personal information. And many of the breaches that have occurred recently in the US have impacted user credentials. So that is also significant to the extent that a business experiences a breach that perhaps does not impact financial information or an individual's social security number, but if at least online credentials are compromised, that could trigger a notification requirement, and that could also trigger the private right of action under the CCPA. And Virginia and Colorado have also followed California in adopting comprehensive privacy laws, although the Virginia and the Colorado laws have taken a lot of concepts and definitions from the EU GDPR in terms of the definitions of data controllers, data processors, and what it means to process personal information. And those state laws do not currently include a private right of action. So that is one difference from the CCPA. And in addition, the Virginia and Colorado laws require that businesses who collect personal information from residents in those states, that they perform data protection impact assessments. So that is another similar element with the EU GDPR. And with that background, we wanted to turn to a discussion of some hypothetical scenarios that involve the application of some of these laws, really to discuss the challenges in the US with responding to incidents and complying with applicable federal and state laws, given this broad patchwork. So Stephanie, do you want to start out here?
Yes, thank you, Tracy. That was fascinating, and I hope that some of our brothers and sisters in Colorado and Virginia in the Mackrell family will consider giving a webinar on those laws because they are in and of themselves complex and not entirely identical to California's law. That was a great overview. I think what I am so fascinated with, especially with our colleagues here, we've got a lot of folks here from the Mackrell family, like Henrik Nelson in Sweden, and we've got Michael Carrie from Colorado, both of whom I've worked with on our clients' privacy matters. That the US really does have a different approach to privacy and data security generally. We have always been more focused on data breaches and notifying consumers after the fact of a data breach so that they could hopefully protect themselves from identity theft. That's so radically different than from the EU, which has had privacy laws since at least as early as 2000s, maybe earlier, that are really focused on consumer privacy and advance notice and letting them know, what, information is, being collected about them and giving some options and choices with regard to that, with regard to data collection practices. So in the US, California was the very first state that passed a data breach notification law in 2002. It went into effect in 2003. So in the mid 2000s, how I got into this field was, I was litigating a lot. So I did a lot of computer forensics work. And, all of a sudden our clients started having data breaches. Laptops were being stolen, or people were breaking into offices, stealing PCs, and there was a lot of confidential data. What's fascinating is that, really, again, the US was really focused on, sensitive, primarily like financial information, driver's license, passports, and things like that. Now, as Tracy said, the definition of personal information is expanding in every state. Now, when I first started getting into data breach law, there were only a handful of states that had data breach notification laws. Now, all 50 states and 4 US territories have data breach notification laws. And what's fascinating is that many of them, while there is a lot of overlap, many of them have unique, unique different elements of what is, private personal information that would be subject to a notifiable data breach. So we've put together a hypothetical that's close to some real data breaches that have been happening here in the US. Keith, if we can go to the hypothetical scenario number 1 slide deck. Thank you. This is a hypothetical about a ransomware attack. ChangeUp is a company. It operates a successful website where members can design outfits and dress up characters in various make-believe scenarios where the aesthetic of the outfit affects the success or failure of the outcome, such as a teenager attending her first day of school, or maybe somebody going on a first date or a blind date. To become a member of ChangeUp and to open up, you have to open up an account. You have to provide your email address, your username, and create a password, of course. Interestingly, ChangeUp is also asking their users to provide city and state location and birth date information. For those of you in Europe and other jurisdictions that really limit the collection of personal data on a necessary need-to-know basis, query whether that type of information is necessary. And they also provide means to recover your account by letting you select a security question and selecting an answer. So they can also store credit card information in case the user wants to make purchases of clothing or additional accessories for their outfits. ChangeUp has over 5 million registered accounts, more than half of which are active users. There are users in every US state and territory of the US, as well as in over 100 countries around the world. One day, a customer service rep at ChangeUp started receiving hundreds of emails at help@dressup.com complaining that the game wasn't working right and their selections were not occurring. ChangeUp CEO then received an email with a note that the company's network had been penetrated and that the files were encrypted, and demanding Bitcoin payment to decrypt the files. The note also stated that the hackers have copies of all the user data. So not only did they encrypt the data, but they gathered copies of that data, including names, email addresses, usernames, etc. And they've threatened that if the ransom of Bitcoin is not paid, that the data would be published on the dark web. This is very typical of what we lawyers in the US might face. And again, it's sort of like drinking from a fire hose, all the different facts that come into play and the analysis that needs to be had in order to figure out which laws apply. So Keith, we'll stay on the slide, but all of my colleagues here on the panel are going to talk about, what do you do when this happens? What's the first thing in the process that you're going to do? So first, I think you got to figure out, which laws are going to apply. Do state laws apply? Do federal laws apply? Here, the fact pattern says that all US states and US territories have users in them. So arguably all of those laws may apply, but then you have to go a step further and look at each of those state laws and each of there's 4 territories that have data breach notification laws, and look at those laws to see, do these elements create a notifiable data breach? Maybe not. Usually most laws require a first initial and a first name and a last name, plus a credit card number or a ID number, things of that sort. But here we have email address, as well as the username and the password, as well as the security question and answers to those security questions in order to gain access account. So many counts, California included, have amended their statutes to include account access data, as Tracy had explained. So not every state would this technically be a notifiable data breach. However, again, some users have credit card information, so you have to look at those users and where they're located to determine if their state jurisdiction has a data breach law that includes that type of information. So it's really complex. So you actually have to know where each of the individuals are. And then as to those individuals, what data of theirs may have been compromised. For argument's sake and for ease of this hypothetical, we'll just assume all the information has been compromised. So I would say that this probably triggers most, if not all states. And many countries in the world do not have data breach or even privacy laws, so this may not trigger notification there. But a responsible company would probably want to roll out, for PR and for branding purposes, they may want to roll out a data breach notification process for all of their users. So the other thing too is looking at the nature of this company. It sure does look like they are targeting younger folks and teenagers and minors. So federal law kicks in. We have the COPPA, the Child Online Privacy Protection Act, that has its own requirements. So I believe that this probably does trigger most, if not all, state laws, and certainly the federal COPPA law. And then again, you need to look in those foreign jurisdictions that may have a data breach notification law. So there's also a question about potential regulatory actions and penalties. This fact pattern, shows that, again, federal law kicks in, state laws. Attorney generals in each state do have jurisdiction to enforce their data breach notification law and compliance with their regulations, as does the FTC. So there are both state and federal agencies that have regulatory power, and several, like California, can impose penalties. So there's, again, you're looking at a lot of, digestion of information and analysis that needs to happen literally within the first 24, 48 hours to figure out, whether a data breach has happened, which laws apply, and where does notification need to begin. And then you have the EU, the GDPR, that requires you to report within 72 hours. And I can tell you in a recent data breach that involved 6 million users around the world, that was really frustrating because 72 hours wasn't enough for us to do an investigation about what information was actually accessed or compromised. And but out of an abundance of caution, we had to go ahead and submit a report. It's sort of a check the box, 3-page document under the GDPR. And again, we had to, change that once we did get all the facts, all the information to update that. So it is a little difficult to operate under the GDPR with such a short timeline. In the United States, I know that Puerto Rico has a very short timeline in which you need to report, 10 days. That's the shortest. And then other states like Washington has a 30-day reporting requirement where you need to report to the Attorney General's office about a data breach. And Florida has 45 days. So about half the states now have specific timelines. The other half, California included, say that you need to notify within a reasonable amount of time. So you can't dilly-dally. You really do need to do your homework, figure out what happened, and then be able to provide a data breach notification that includes all the details of the data breach to your consumers that may have been affected. So with that, I'm going to hand it over to Sherwin, who's going to take the next question about private enforcement.
Thanks, Stephanie. Before I get to that, there's probably, I don't know if Carrie or Tracy have comments as well, but one thing that occurred to me as you were talking, just to add to the patchwork, is the PCIDSS component here, the payment card industry data security standards. Tracy mentioned at the beginning, not only do you have federal and state, breach notification laws and security and privacy laws, but you also have industry standards. And the credit card industry is one of those industries that imposes some pretty onerous breach notification and incident response standards on merchants, basically. I mean, the burden ends up falling on the backs of the merchant. So to the extent that ChangeUp, is handling their own credit card transactions here, you mentioned that they're storing credit card information. Mm-hmm. To the extent that they're under a cardholder agreement, they're going to be responsible for responding to the PCI-DSS standards as well. And having done some of that work, I know that can be much more onerous than a GDPR data breach response. Typically, they're looking for some initial, reporting within 24 and 48 hours. Plus, you have to hire somebody who's on their approved list of forensic investigators and pay for a very expensive report that goes to the card brand. So things are kind of out of the client's hands at that point, unfortunately. And of course, you have all the other breach notification obligations that Tracy and Stephanie walked through as well. So it just highlights that this patchwork is truly a patchwork and something that requires some thought, some forethought, and some preparation. And hopefully, we'll be able to give you some takeaways at the end of the presentation. I guess one of the questions is, in addition to the government enforcement or regulatory enforcement that Stephanie mentioned, what are some of the other avenues for enforcement, private enforcements? Tracy talked about, for example, in some of the comprehensive consumer privacy laws, California and Virginia and Colorado, that one of the differences in those laws concerns private causes of action, private rights of action. So indeed, there could be common law causes of action that ChangeUp is going to be responsible, to answer for here. A negligence class action suit, for example, based on failure of security standards. Maybe they try to bring it outside of any privacy statute, irrespective of whatever applicable enforcement mechanisms may have been built into those regulations. They may just go for U.S., common law, tort actions. We see that a lot. There are many obstacles to those litigations, two of which, or one of which is damages, showing harm. So just the fact that ChangeUp's customer information has been let loose in the wild, or has the potential to be, if they don't pay the ransom, does that mean that users have been harmed, that ChangeUp users have been harmed? And those questions are still being answered. When you talk about a patchwork, the US legal system is very much like that, the judicial system. So you're going to have state lawsuits, and different states handle things differently. You're going to have potentially, federal actions or national class actions that are handled in one particular state on behalf of everyone impacted. And the question will be, were they harmed? And typically harm has to be demonstrable, something that you show with evidence, and can't be speculative. So that's the first hurdle that change-ups complainants are going to face, is to be able to demonstrate damages. But that's why statutes like the ones Tracy has talked about, those comprehensive statutes, are real game changers, because some of them are looking past whether or not there were damages, and they're giving you the user statutory damages, whatever it is, 2,500, 7,500 per claim or per record lost, or whatever it may be under the given statute. Now, there's no longer a need to necessarily demonstrate harm. You can just show that change-up violated some law, maybe under CCPA, related to the protection of that consumer data. And then, then the plaintiff's lawyers are off and running. One of the other problems that complainants face is causation, right? Because I bet of the 40 or so participants on this webinar, probably 40 of us have received breach notification letters, are under some credit monitoring program, whether because it happened with our e-commerce, provider, or email, Yahoo or Target or Home Depot or whatever it might be, which begs the question, which is the breach that harmed me? Which is the breach that exposed my information? That's one of the other obstacles. That said, these suits are still coming, and we see them settling all the time, and in 7 figures and higher, for those class actions in particular. And of course, just because you might face obstacles as a litigant doesn't mean that you can't bring a claim and try to settle it. So that's a real risk, and it adds to the complexity and the challenge of this patchwork of US privacy laws. I think that's all I'm going to say on that, and I'll turn it over to my colleagues. I don't know, Keith, if you're moderating from here, or if there's other comments on this particular scenario that others on the panel have.
Sherwin, go ahead, Tracy.
Go ahead, Carrie.
I just wanted to mention, the clients that we've worked with who have experienced ransomware attacks often are fortunate enough to have cyber insurance. So, when something like this is happening, they're usually partnering, with forensics folks to really figure out, if what the attacker says is in fact true, whether information was actually accessed or if it's just locked up. And all those things are really critical in determining, whether there was an actual breach. As well, often your insurer is willing to help you work to figure out what was the vulnerability in your system. Was it your technical hardware, or was it, people? Because we all know that, people are our biggest weakness in our systems. So it's really critical to work with your insurer and then your forensics team to determine, how you, in addition to addressing the legal requirements of what happened with the specific attack, how to prevent it from happening in the future.
Yeah, good point.
And I would also add that the issue of ransomware is currently, there has been legislation introduced that would require at least critical infrastructure entities to report ransomware attacks, and also some other types of businesses to report attacks before paying ransomware. And that is also an issue in this case, is whether and when ChangeUp should pay the ransom, and what agencies, if any, ChangeUp should reach out to. So the FBI and the the Cybersecurity and Infrastructure Security Agency, in recent years, they have issued a lot of guidance for both critical infrastructure, but also businesses and other industries as well on ransomware attacks in particular. They identify certain types of attacks that are more common from time to time. So it is important for businesses that do have internal security teams to remain up to date on the guidance, but we also now need to watch the landscape to see what legislation, if any, might be adopted governing mandatory reporting of ransomware attacks.
I have a question which is coming from Zach Clayton, which is, can arbitration clauses in privacy policies or terms of service protect against class action suits in data breach situations? Who wants to take that?
I can respond to part of that. So I've been doing several webinars with Ian Ballon, who is sort of international, well-known expert on cybersecurity class action litigation. And he strongly encourages that people use arbitration clauses. It can be in your privacy policy. It can also be in your online terms of use, and certainly in your contracts. Now, whether it can prevent a class action suit depends on the quality of the arbitration clauses. But yes, you absolutely can compel arbitration. He strongly recommends that. When I've worked on contracts, I've always sort of not enjoyed putting in arbitration clauses, wanting litigants to be able to choose whether to use the judicial system here in the United States. But absolutely, the answer to that is yes, arbitration clauses work, and they should be used and carefully crafted and drafted so that they're effective.
Yeah, I agree with that, Stephanie. And there's lots of do's and don'ts with respect to that, and the ultimate arbiter or decision maker about whether a class action clauses or a waiver of class action, for example, and compelling arbitration is going to work it'll be state law dependent. It really will be. And I think that there are rules in each state or best practices for making sure you have the best shot possible at making sure your waiver or your arbitration mandate sticks. So, making sure that it's very clear up front before the consumer engages you, what they might be waiving in all caps and all of that is very important. So you just want to make sure you have counsel on that. The other point, Keith, I'm sorry to piggyback on this particular question, but Tracy's point about ransomware and the laws about reporting remind me that our listeners probably, or our attendees should probably also take heed to the Department of Treasury's advice this year, both through FinCEN and the Office of Foreign Assets Control. They've sort of issued warnings to the general public that if you make a ransomware payment, through Bitcoin or whatever, just be very confident that you're not sending that payment to somebody who's on a state sanctions list, which is very often the case. These ransomware criminals are sometimes state sponsored, or they are criminals who are on a sanctions list, and that you're avoiding offending anti-money laundering, laws. So just keep in mind that that's another dimension to this ransomware scenario.
Excellent point. Yes.
Thank you, Sherwin. Conscious of time, conscious we have another hypothetical, and we also want to look at best practices. And what's coming out of this is we call it a patchwork, but it's much more like a sort of mixed up Rubik's cube. It's in multi dimensions, and so I think getting to the next hypothetical and the best practices is probably quite key, because as a potential client, my head is spinning already. So Carrie, I think you're going to take us through this.
Yeah, I am.
Hypothetical 2.
Sure. And I just wanted to preface before I start talking about the hypothetical, my practice area is a little bit different from my colleagues. I have the pleasure of working with school districts in Arizona. And so they are the steward of rich records about children and rich records about employees as well. The framework that governs how school districts are to care for educational records of students is FERPA, the Family Educational Rights and Privacy Act. And my practice area is really focused on helping school districts comply with their obligations on FERPA while also teaching students remotely, complying with public records requests about COVID, partnering with healthcare institutions that want to have clinics in their schools. There's a lot of best practices I'm looking forward to talking about in our next section, as I've worked with school districts on, being good stewards of the educational records they're entrusted with. So the second hypothetical came out of a situation that actually just recently happened in Phoenix. And it's something that I think is very common. So it's the inadvertent disclosure of confidential information. So in this case, a well-intentioned hospital employee sent an email to employees who were determined to be exempt from the new COVID-19 vaccine requirement. And the email was to more than 300 exempted employees who were CC'd so they could see each other's email addresses rather than be CC'd, thereby identifying all those persons who were eligible for the medical or religious exemption from the COVID vaccine. So this immediately became the lead story on the news over the weekend when this happened, and a plaintiff's attorney became involved on behalf of one of the affected employees. I wanted to mention a couple of the sort of salacious quotes that I thought were really interesting in the story. So one of them was from one of the persons whose name was on the CC list. My biggest fear on this is that, gosh, this is a hospital. If people are trying to entrust them with all kinds of sensitive medical information, and if they can't get something like this right, what else aren't they doing right? Is this the first kind of data breach that comes out, or what else has been leaked that we just don't know about? So I think this is a really common situation. The first thing we wanted to talk about is, are the data breach notification laws really triggered here? What was disclosed by this hypothetical? So I can take it unless someone else wants to speak. So what do we know by this disclosure, right? They told people who either had, an ADA disability, an accommodation, or a religious exemption that they didn't have to receive the COVID-19. Those are the two possibilities. From the information we know, we don't know, each group, who was in each group. So, any person on that list might have had a medical exemption or religious exemption, we don't know. So I think there's some question about whether the data breach statutes apply, but I'm interested to hear what my colleagues think on that.
I think I'm off mute. Hi, Carrie. So to me, this, the first question that people might think is this a HIPAA breach? And one thing that, and I just did some research on this last night for a client, in the employee context, in the employee-employer context, employers are often exempt from HIPAA privacy rule. And so in this context, I would say that a HIPAA breach did not necessarily occur, because it's in the context of employees as opposed to patients. It is health information, it is a covered entity, but to the extent that the covered entity hospital is also an employer, and this is employee data, and it's being processed using GDPR terminology in the context of an employer obligation, as opposed to a medical care provider under HIPAA that would trigger applicability of HIPAA under as a covered entity, I would argue that it doesn't apply here. But the other thing, though, I've had a lot of clients who had similar things happen because inadvertent emails happen, and their better practice is to still notify and go through some of the protocols that you would under a regular data breach. The other thing too is under HIPAA, if HIPAA were to apply, it's a very different scenario. There's a weighing of risk that happens to determine whether or not it's a data breach under HIPAA. So under state laws, and again, every state is different. In California, you actually need to show acquisition of the data, and that's it. So whether or not it's it could be a person, at another company, they're not going to, steal the identity of the individual or individuals whose data has been compromised. So under HIPAA, that might not be a high risk or might not constitute data breach, but under California law, because there was acquisition, that in and of itself constitutes a notifiable data breach. So again, HIPAA has a very different way of approaching whether or not a data breach happened compared to state laws. And some states, have a lower standard than California. It would be, or a higher standard, I should say, just mere access. Maybe they don't have acquisition, but they had potential access, and that would constitute a data breach. So every state and also federal laws have different ways of approaching whether or not a data breach happened.
And I would also add to that, Stephanie, that more states, including California, have amended their laws to include medical information and the definition of personal information for data breach notification purposes. So if the facts here were a little different and the recipients of the email all suffer, if they were all consumers who suffered from a certain condition, or there was information about a medication, I think that would be more likely could trigger notification under some state laws. And now under the CCPA, that could also trigger a private right of action if that amounts to a breach under California law.
Yes. And unfortunately, each state, not every state, but I know California, I can't speak to all states, but for instance, California has its own California Medical Information Act. So, and it supplements HIPAA. So HIPAA does not, preclude it. If HIPAA doesn't get triggered, the California Medical Information Act may be triggered. This happened in Arizona. So we're not dealing with, with California consumers, but under the CMIA, I know that it's $100 a day per incident, per individual penalty that keeps accruing until you get the notification done, completed, right, and you reported to the California Health Department. So more fun.
So even if in this situation, there's not legal liability for the hospital, obviously, the affected employees are, drumming up public interest in this, which is damaging to the hospital's reputation. And so I think it's important to talk a little bit about communication. I feel like with every data breach, getting out in front of it and being honest with the community that's impacted is really critical, as well as, what controls in place did you have in place with your employees? Did they know that privacy is a part of their job? I'm happy to see one of the school districts I work with on a daily basis that really takes data privacy seriously. It's really a partnership, and there should be some kind of quality control in place. In this case, obviously, was the employee properly trained on how to communicate this kind of information? The simple, issue of CCing instead of BCCing had such a big impact, allowing employees to take time to do their job with care. Maybe someone having a second set of eyes on something that's of a critical nature that contains private information, just so that, there's a little more care so something could be caught rather than having to deal with the cleanup of the situation. I work with schools on producing public records all the time. And we've had so many records requests related to COVID-19. And it's like looking through a needle in a haystack for a needle that might not be there. Really looking to make sure that, although you're complying with your obligation to provide records that are of a public nature, you're also making sure that no, student records or employee records are buried in an attachment, and taking the time to look through those things with a critical eye.
Excellent hypothetical.
Carrie, you made the statement about employees having to understand that they are responsible for people's privacy. Do you think, and a question to all the panel, in terms of your interactions with clients, do you think that businesses nowadays understand that they have a responsibility and a duty to make their employees understand that specific point, that almost whatever your role is, you as an employee are responsible for safeguarding privacy?
You know, every situation where I've dealt with an inadvertent disclosure has been with a good employee just trying to do their job, but perhaps in a rush and making a mistake. And so I think it's really critical for employers to make sure that their employees know what private information, you know, they're dealing with. You know, in my case, it's whether it's with employees or with students, and understanding that although something might be critical, ensuring the privacy of that confidential information is much more important than whatever the urgent, you know, thing needs to be done. And really, you know, for me, it's talking to, you know, my school districts about, you know, having a second set of eyes on something, or having some kind of quality control process in place to making sure that something doesn't slip through the cracks. Because, you know, the cleanup on these situations is so time consuming and damaging to the reputation of the client.
Keith, I to answer your question, at least in my world here in the Northeast, in Connecticut in particular, I would say no. I would say many businesses do not understand the importance of, you know, training employees and investing privacy and security awareness, and that's why we continue to see more and more legislation and regulation in that regard, either requiring, you know, written information security program like Tracy mentioned in Massachusetts, or in certain sectors. We have the same thing here in Connecticut. We also have laws now, a law just recently incentivizing businesses to adopt one of the recognized cybersecurity frameworks. And the carrot that they put in front of the business is you won't be sued for punitive damages in the event of a data breach if you can demonstrate that you have a security program. And of course, a security program would include employee training. So employee training is critical, but unfortunately, I don't see it happening a lot until there's an incident like the ones that Carrie has described, or a new law comes. I've gotten a number of calls since this new Connecticut law. You know, how can we get on board with this cybersecurity framework? Like, we've been preaching cybersecurity frameworks for years, and so this incentive of avoiding punitive damages is now something that's prodding some businesses here, at least in Connecticut. So sadly, I would say no. I would say many employers are not thinking about that. They've got a lot of other things to think about, but I think they should be, and that's like one of the number one things you can do to prevent even ransomware attacks, like we talked about before, because it probably happened because a change up employee clicked on a phishing email that they should have recognized had they had the proper training.
And as we move to a discussion of best practices in the last few minutes, I would also add to that the importance of having an incident response plan in place. So employees and others internally know who to contact, who is the first point of contact, including what agencies might need to notify if in the event of a ransomware attack, should the entity reach out to the FBI. So really having that plan in place, and I also considering what happens if systems are not accessible. How will employees communicate internally? You know, typically we advise that they confer over the phone to the extent possible rather than exchanging emails, especially if the system has been compromised. So I think that's also a key element in addition to an information security program.
In my practice with schools, one of the best practices I try to implement is really data minimization. So by that, I mean, you know, when they're working with community groups that want to do something wonderful for the students, you know, to improve student outcomes, or they're implementing, you know, a great technology for classrooms, is figuring out how the tool is being used or what, the process is, and determining, whether the school district should be sharing personally identifiable information at all. Always trying to share the least amount of PII possible. And then also having strong controls around what, how the user can have the information, with regard to sharing with third parties or destruction, upon request of the district.
And under many laws, de-identified or anonymized data does not constitute personal information. So in addition to minimizing collection, it's also important to look at what information can be segregated, what sensitive information can be segregated. So if certain information is accessed or acquired, perhaps that would not affect other information that's being maintained.
So Keith, I think everybody has given such good takeaways, and I think they should be recapped. Tracy, or actually Carrie, talked about getting cyber insurance about 30 minutes ago. Super critical, because most general liability policies now exclude data breach and cyber events from coverage. So that was an excellent takeaway. Tracy's comment about data breach incident response plans, I agree 100%, because I will tell you, it's like drinking from a fire hose. All my clients are like a deer in the headlights when a data breach happens and they don't have a data breach incident response plan that they've actually practiced with their team. So, I thought that was great. And then of course, Sherwin's comment about the necessity of training employees. Most companies, I think, just still are, sort of have their heads buried in the sand. They don't want to see the reality and the risk. And so I think training employees is super critical. I'd like to add, look at your third-party vendor contracts. We didn't cover that much today, but a lot of the data breaches that make the headlines, a lot of it is the infiltration came through a vendor. Target is a perfect example. That happened in 2013 and made data breach a sexy word here in the United States. That happened when an HVAC vendor employee clicked on a phishing email. Infiltrators got access to the HVAC vendor's computer systems, which had access to Target stores, because they measured, they used the payment card processing system to measure the traffic in the stores to determine if they needed to increase heat or increase air conditioning and things like that. That is how the Target breach happened. It was through a vendor. So in addition to employees being a potential weak link, so are your vendors. So it's really critical that your written agreements contain terms that require them to comply with applicable privacy and data security laws, and also that you're going to have that they're making reps and warranties that they have adequate security measures in place, both physical, technical, administrative security measures in place to protect data. And that, if they violate those reps and warranties, or if they are the cause of a data breach, that they're going to defend and indemnify you, the company, because you're the one who actually has the legal obligation under the law to do the notification and report to government agencies about a data breach, if it's your consumers' data or your employees' data, if it's, if that's what's at issue. So reps and warranties, indemnification, and also you can require them to have insurance, cyber insurance, and make sure that you're named insured on those policies if a data breach happens.
I think we've probably got enough for a day's roundtable discussion rather than just an hour's. But just as we wrap up in the last few minutes, I'm going to go around the group. Thank you for those takeaways, Stephanie. And you've probably stolen a little bit of Tracy's thunder since you referred. But if we just go around and say, Tracy, 2 or 3 takeaways that people should take away.
Sure, it's very important to start with mapping the data and look at the types of information that are being collected, what regulatory obligations does the entity have, and which laws are triggered, whether the entity operates globally, nationally, or just in a few jurisdictions. I think that is an important first step, is really, and also looking to Stephanie's point about vendors, looking at parties with whom the information is shared, and also looking at how that information is being secured. And entities that are already obligated to comply with the EU GDPR can leverage some of the work that they have done to comply with the GDPR, although there are some significant differences between the GDPR, the new California Consumer Privacy Act, and some of the other, the new Virginia and Colorado laws. But I think that is also a useful starting point for entities that have already gone through the process of updating privacy notices, conducting risk assessments, and having vendor contracts in place.
Brilliant. Thanks, Tracy. Carrie, how about you?
I think I'm piggybacking on Sherwin's statement earlier, is really elevating the notion that data privacy is a part of everyone's job. It's not just the job of IT. You know, I've seen a lot of school districts that, you know, employees assume that IT is taking care of things, and, you know, they're not looking at the privacy aspect, and really training employees on that and letting them know that that's an expectation of their job as well.
Thanks, Carrie. And Sherwin, just we'll give you the last word, but I'll start with a question then. Everybody on this call has a fire drill, and we do that I would guess, every month. Should there be a requirement for businesses to have a training refresh once a quarter, twice a year, something like that?
Yeah, I highly recommend the training. I can't overemphasize that. It's just, it really lowers your risk profile. It gets everybody involved. If you do it in the right way, where it's positive and people don't feel bad with reporting incidents, or, you know, there's not an atmosphere of fear, but a sort of a collective pulling in the same direction to let's just tighten our controls. I think that's excellent. I would also suggest that businesses look at what they already have available to them. You know, we have Office 365, lots of people do. There are security controls there that you could just turn on, like two-factor authentication, and there are certain, you know, regulatory compliance tools that you can just turn on. You might have to pay a little extra, but you can spot an email like this hospital email. It might not have gone out if they had this program running that allows them to alert the employee, this has sensitive information. It looks like it might have medical information or whatever it might be, depending on how it's configured. Those little things can really help, but training the people themselves and getting them invested. Anti-phishing campaigns, you know, sending them fake phishing emails and seeing who clicks and who doesn't, and reinforcing the training. Very important.
Brilliant. Sherwin, Tracy, Carrie, and Stephanie, thank you so much for all of your insight. I feel we've really just scraped the surface, but I hope for everybody on the call, you've got at least a sense of the Rubik's Cube, the patchwork, the complexity of what's going on, the need to stop and think about this collective response in your businesses, whether you're in the US or anywhere else across the world. And it's great to see colleagues and clients from outside the US tuning in. We may revisit this, but in the meantime, thank you very much for joining us. Thank you for our speakers. I will be circulating the slides and contact details should you wish to pick up with any of them individually or as a group. And we look forward to seeing you at the next Mackrell International Roundtable, and we really hope you found this of value. So thanks very much, everybody, and look forward to seeing you again soon.